Mr. Jones and Aaron Berger, your mics are still muted. Okay, I think you took care of it. Thank you.
Good morning, Your
Ready to
Honor.
go? Good morning. Appellant, you ready?
Yes, Your Honor.
All right, proceed.
May it please the court, my name is Aaron Berger. I'm from Giassi Law, PA, and I represent the appellant, Mr. Barrow Minaldi, in this case. I'd like to reserve 5 minutes for rebuttal, please.
You got it.
This matter arises out of a property insurance dispute between Mr. Barrow Minaldi and his insurance company, Citizens Property Insurance Corporation. Mr. Barrow Minaldi sued Citizens for breach of contract after they did not pay his claim arising from a water leak in his kitchen. After he discovered the leak, he hired a water remediation specialist. He reported the claim, participated in 2 inspections, provided recorded statements of him and his wife, provided a sworn proof of loss and other documentation in support of his claim. He requested the status of his claim several months later, and then sometime after that, the insurance company requested an examination under oath. And for purposes of abbreviation, I may refer to that as an EUO, Your Honors, and I didn't want to confuse you if I do that. Appellant then sued after he attempted to sometime later coordinate that EUO after some time had passed, but the insurance company did not want to do that. And then this underlying matter was initiated in October of 2017. One of the first issues that I'd like to discuss, Your Honors, is that the first issue on appeal raised by the appellant, that there was not sufficient summary judgment evidence to support this final judgment. And in the answer brief, the insurance company essentially concedes that issue. And footnote 2 of their answer brief, they admit that they did not properly authenticate the documents that were attached to the affidavit presented by its corporate representative. This concession should be dispositive of the issue and should require reversal by this court for further proceedings. Although they make this concession—
Absolutely. If I read Judge Holder's order correctly, he bases his order on the fact that it was 19 months from the time of the claim until the examination under oath eventually was conducted. Is that right?
Well, there was no examination under oath conducted. That much time, I believe, had passed, approximately that much time between the claim and the time that Mr. Barrow Minaldi offered to coordinate that before proceeding with this lawsuit.
Was that the total basis for the lower court's ruling?
It was the only basis for the lower court's ruling. At the hearing, the judge expressly rejected one of the arguments presented by the insurance company, that Mr. Barrow Minaldi breached the contract for failing to retain the damaged portions of the plumbing. Although other arguments were raised in the motion, they were not argued at the hearing, and other arguments were raised at the hearing that were not raised on the motion. But the court expressly stated that his decision was based solely on the EUO.
So why is that an error?
That's an error, Your Honor, because again, the evidence here has not been, the evidence that was presented by the insurance company was not properly authenticated or presented. Although the insurance company concedes that they didn't authenticate the documents as required by the business records exception of the evidence code, they argue that their affiant's knowledge should be presumed because she was an agent of the corporation. The argument that her knowledge is presumed is based on, case law from over 40 years ago that says that, perhaps a corporate officer or agent may have the requisite knowledge to testify from personal knowledge about a business's practices or policies. But this case is more in line with this court's Rodriguez decision from January of this year, Rodriguez versus Avatar Property Casualty Insurance Company, where this court reversed the summary judgment, where it's the same situation where an insurance company's affiant did not provide any details of who she is, what she does, how long she'd worked for the insurance company, or any basis from which the court could assess the competency, her competency to aver to these things that were included in the summary judgment affidavit.
So you're saying they failed to carry the burden of proof to rebut his affidavit? Was there an affidavit by Mr. Minaldi saying he wanted to comply with the examination under oath? After the fact, after he filed the lawsuit and took a dismissal?
The answer to that is twofold. My argument is not that they didn't rebut his affidavit. Well, they did not. But my initial argument is they didn't meet their burden, period, because they haven't presented sufficient admissible evidence here to support that, A, they even requested multiple EUOs, or that any sort of communication took place. Because
well, I thought you said initially that there was difficulty in scheduling it and they didn't want to keep working around the insured's schedule. I mean, it didn't seem to me that that was a point in dispute. They asked for an examination under oath, and it was flat out refused. Is that true?
Your Honor, the issue is more akin to, there was a recent decision I'd like to point the court's attention to from I believe it's the 4th District. It's within the last 30 days, Abdo versus Avatar Property and Casualty Insurance Company. Here, the issue is that after the claim was reported, the insurance company has, a certain amount of time per the statute and per the policy to adjust the claim. They didn't do that. They only requested the EUO. It was like 5 or 6 months after the claim was reported. And it's our position that at that point in time, a decision could have been made and should have been made. And so the request was unreasonable. The depositions that were presented.
So you're saying there was justification for refusing to engage in the examination under oath at that point prior to suit being filed?
In the trial court, the appellant did provide an explanation for his non-appearance that creates a genuine issue of material fact. At the depositions that were presented with the insurance company's motion for summary judgment, neither Mr. Barrow-Minoldi nor his wife remembered being asked to attend an EUO unequivocally. They seemed very confused by the request and what even an EUO is. Mr. Barrow-Minoldi's wife didn't have any recollection. Neither of them could identify any of the correspondence that was purportedly sent to them, which calls into question or relates to the issue I was bringing up with the new case, Abdo versus Avatar Property Insurance Company, which I'll file a notice of supplemental authority with the court. In that case, the insured did not appear for an EUO, but there was a question of whether the attorney for that insured even communicated with the insured. And when the insured realized it and had new counsel, they requested to coordinate an EUO, but by that time, the insurance company refused to coordinate an EUO. So we kind of have the same situation here where, there is a question of fact is whether or not what the appellant knew and did not know at the time that the lawsuit was filed, the first lawsuit was filed. Again, the depositions make it pretty clear that there's a question of fact there, whether or not they knew and whether or not it was willful. And that's the question here, is whether or not if there was a material breach, which Citizens argues there is, whether or not it was material and whether or not it was willful. And the cases that were cited by the appellant in our briefs, since Goldman, which is the case that, since Citizens request that the court look solely to, all those cases since then say that if there's some sort of partial compliance or an explanation for non-compliance, then it's a question of fact for a jury to decide whether or not there was a willful and material breach and whether or not there would be prejudice. And whether or not there's a material breach begs the question of prejudice. In the answer brief, Citizens Insurance Company or Corporation argues that there's no reason for the court to consider prejudice, but the cases that are cited, including cases from this court, Curtis versus Tower Hill, Macrolos versus Citizens, those cases state specifically that those are questions of fact for the jury.
Well, didn't Barrow's lawyer refuse to allow his clients to sit for an examination under oath? Didn't he say the request by the carrier was unreasonable?
That was an argument that was made, but again, the question
that's not in dispute, is it? Maybe the clients didn't understand everything, but the lawyer representing them led the charge in the refusal.
I think that's what can be gleaned from the hearing argument, Your Honor. But again, in the Abdo case, the question is not whether or not that knowledge, or the question is, that knowledge cannot be imputed to the insured to find that the insured willfully did not comply with the terms of the policy.
Okay, I got you.
And again, turning to the question of prejudice and whether or not this was a material breach, the Fifth District Court in Allstate versus Farmer equates the two. Material breach means, excuse me, causing a prejudice. And in the initial brief, the appellant cites to the Curran case and that type of analysis regarding conditions preceding, conditions subsequent, while the answer brief by citizens challenges the reliance upon the Curran decision in this case because it has been sort of limited in some situations to the excuse me, insurance policies. The reasoning there is still the same, and it applies in other contexts that this court, I'm sure, is familiar with in the foreclosure context, where, you know, if compliance with conditions precedent is raised as an affirmative defense, it's upon, you know, the parties to demonstrate that there was a material breach and whether or not they were prejudiced by that breach, and that's essentially the reasoning that was applied in the Curran case. This court in Curtis versus Tower Hill concluded that an insurer is required to demonstrate prejudice before it can be the insured can be held to have forfeited benefits by materially breaching an insurance policy's requirements. There's another recent case, Your Honors, within the last 30 days or so out of the Third District, Naveen versus Universal Property and Casualty Insurance Company, which relies on the authority of Estrada, which were cited in the briefs, finding that trial courts are required to analyze whether the insurer was prejudiced by the insured's failure to comply with duties after loss. Here, there doesn't appear to be any prejudice. You know, when it was offered to them, they did not want to do it. There was no suggestion in anything that was provided to the trial court as to how an EUO would have offered them, you know, any information that they didn't already have to be able to make a determination. By the time, you know, this second lawsuit was filed, they had taken the depositions and apparently had enough information to, you know, oppose the claim at this point. The insurance company argues that there's alternative basis here to affirm the trial court's decision, but there are no alternative bases. The only other issue that they raise in the answer brief is whether prompt notice was given. Again, this was not an argument that was raised in the motion for summary judgment. There was nothing in the trial court's order or in the hearing that suggests that the court even considered this issue. Based on this court's authority and the bank or precedent of the Bank of New York Mellon versus Blodel from 2016, this court should not consider that issue at this point because there the court noted that although the homeowner had raised other bases to support the involuntary dismissal that was entered and that this court ultimately reversed, the court did not consider those issues on appeal. And the same conclusion was reached by this court in the Rodriguez case, where the court said there's other issues that are probably going to come up, and specifically talked about whether or not prompt notice was given, but they did not affirm the summary judgment on that basis at this stage of the proceedings. Even if the court were to consider the issue, genuine issues of material fact remain. The only facts that citizens relies upon for that issue are the fact that there was some space and time between the date of loss and the reported loss, and that they had made some repairs in between. But those facts don't create conclusions that support final judgment. There's genuine issues of material fact as to whether or not, again, you know, there's been argument presented below that there was no prejudice to them at this point. And for that reason, the appellant would request, and the reasons already discussed and briefed in our answer or initial brief and our reply brief, we would request that the final judgment be reversed and remanded for further proceedings.
You've got 5 minutes left for your rebuttal. I'll save that. Mr. Jones, response.
Good morning, and may it please the court. My name is Ryan Jones and I represent Citizens Property Insurance Corporation. The trial court's entry of summary judgment should be affirmed because the court correctly concluded that there was no genuine issue of material fact and that Citizens is entitled to judgment as a matter of law. I want to take just a moment to go through the facts because the way they were presented was a little bit unclear. The facts that are completely undisputed are that the policy of insurance at issue has a requirement that the insured submit to an examination under oath.
Prior to filing suit.
prior to filing suit. That's correct, Your Honor. Citizens made a request for an examination under oath, and appellant, through counsel, responded by rejecting that request and filing suit. The other matters about...
Was there a coordination issue? Was that the cause for the rejection in the record, or some other issue?
No, Your Honor. The reason for the rejection was simply that appellant, through their counsel, felt that the examination was unnecessary and therefore completely refused to attend and instead filed a lawsuit.
Not because it was not in the policy. Not because it was not a provision in the policy.
Correct.
Just opinion, okay.
Correct. It was their opinion that the EUO was unnecessary, but it is undisputed that it is a requirement of the policy. All of the discussion about submitting to the EUO only came after the request was rejected, after suit was filed, after litigation went on for almost a year, after the appellant submitted to a deposition in the first lawsuit, and after a motion for summary judgment was presented on the failure to submit to the EUO. In fact, it was the morning of that hearing that the case was dismissed. And
well,
after
I have
that,
a question.
yes, sir.
I just wanted to, I don't mean to interrupt you, but procedurally, the plaintiff filed a notice of voluntary dismissal. Is that true or false?
That is true.
Okay, and they did it the morning of the hearing, knowing full well that the pleading they was served by citizen contained an affirmative defense of failure to submit to an examination under oath. Is that true or false?
That is true.
Okay, and they did it without getting permission from the court to abate the action while they complied with the EUO or the consent of citizen to refile with the condition that they would abide by the examination under oath.
There's nothing in the record to indicate that that statement is anything other than true.
So they
And
just filed a whole new lawsuit after complying with the examination under oath. That's the only thing that changed. And now they're saying there's no prejudice. Is that essentially where we are?
I understand that they are arguing there's no prejudice, but the primary argument, I believe, is that appellant believes there's a question of fact as to whether or not they attempted to comply with the EUO provision. And
that was never raised at the notice of voluntary dismissal or any court proceeding prior to this summary judgment.
That's correct. The prior court proceeding, the hearing did not go forward. In fact, it was the morning of that hearing that appellant voluntarily dismissed the case. The hearing did not go forward. And approximately a month later, appellant's counsel sent an email to citizens counsel saying, we will now submit to the examination under oath, which citizens counsel responded by saying, no, it is too late. You cannot submit to the examination under oath now.
In other words, you can't undo the breach. There's been a breach. It's a material. You don't get a redo.
That's exactly right, Your Honor.
Okay.
And
Gotcha.
all of the facts that I've just outlined, the ones that are most critical are the fact that the policy contains the EUO requirement, the EUO was requested, and the EUO request was rejected. All of that is contained in the record through admissible evidence in many different sources.
And what would have been the hearing had the hearing gone forward before the case was dismissed?
Well, it was a motion for summary judgment hearing, and it was actually before the exact same trial judge, and there is no difference.
But it was a different basis. It was the same basis as failure to comply with the EUO provision? Essentially the same motion that eventually was granted?
Yes, Your Honor, that is correct.
Okay.
It's the same issue, the same judge, the same parties, and from what we can tell from the record, the same facts. So the important part is that the facts are in the record and they are in the form of admissible evidence.
But we don't know why the notice of voluntary dismissal was filed, whether it was an attempt to avoid the inevitable in that proceeding or some other reason.
Your Honor, I'd submit that the only logical inference is that it was to avoid the inevitable and attempt to, after the fact, comply with the EUO request, because the vast majority of case law is against an insured refusing to submit to an EUO. In fact, this court's issued a decision in the Drummond case that specifically says a failure of the insured to submit to an examination under oath before suit is filed bars recovery, period. So according to that decision, the trial court reached the right conclusion. And this court's not alone in reaching that decision. There are many other courts that have reached the exact same decision.
I mean, I think there's some dissent and concurring opinions by Judge Warner, but I'm not sure of any other authority, and that's not really authority, but all right.
And Your Honor, I can address the dissents and the concurring opinions because first of all, they're not controlling authority, but second of all, what those address really is what the mechanism is after the breach of the contract. Because once you have the breach or the refusal to submit to the EUO, there is a line of cases that suggest that is the end of the inquiry. The insured is barred from recovery. And under that line of inquiry, the trial court reached the right decision and it should be affirmed. The other line of cases, which are what's suggested by the dissents and the concurring opinions, and actually there's another line of cases most recently articulated in the third DCA's Estrada opinion, that say once you have a breach of the condition or a failure to submit to the EUO, there also has to be a prejudice analysis. And in that analysis is one more step. The additional step presumes there is prejudice to the insurance carrier and places the burden on the insured to show that there was no prejudice. In this case, if we look through the record, there is absolutely no evidence to suggest the prejudice can be rebutted or the fact that there was no prejudice at all. So even if we were to apply that analysis, the result is the same and the decision should still be affirmed. I do want to take just a second, though, and address counsel's reference to the recent Abdo decision. And the Abdo case is very distinguishable from what we have here. In Abdo, counsel pointed out that the knowledge of the attorney could not be imputed to the insured. But the key distinction between the two are in Abdo, the insured submitted an affidavit stating that he was not aware of the EUO and never refused to submit to the EUO. That is directly contrary to the evidence we have here. There is no such affidavit from the appellant. In fact, appellant's affidavit that is submitted says that he is aware of the EUO, and he also believed the EUO was inappropriate and did not attend the EUO. So this is completely distinguishable from Abdo, and the trial court reached the right decision. I do want to take just 1 second and circle back to appellant's argument that the evidence wasn't presented right, because the letters that we acknowledge were not authenticated as business records are not necessary to support the trial court's decision. All of the facts that we've just discussed are stated positively by a litigation specialist who provided an affidavit from citizens. And if we look at all of the cases, the focus on whether the evidence is sufficient is the ultimate question is whether that evidence would be admissible at trial. And when these first party cases are tried, the insurance companies present an individual. Some call it a corporate representative, some call it an adjuster, some call it a litigation specialist, which is what Citizens calls it. And that individual will outline the basic facts of the case. That's exactly what we have in the affidavit in this case. So the evidence is sufficient. And even if we don't consider that affidavit, we have other sources of the exact same evidence. For example, the appellant acknowledged that the certified policy is in the record and admissible at trial. There is a certificate of non-appearance from a notary public who attested that no one appeared for the examination under oath on the day it was scheduled. And in addition to that, plaintiff's deposition suggested that they did receive the letter scheduling the EUO. All of that information, all of that evidence was attached to the motion for summary judgment. And all of that shows the failure to comply. And even if we don't look at all of that evidence, we still have the affidavit from plaintiff himself, who again said that he was aware of the EUO request and did not appear for the EUO. So what this ultimately boils down to is this court's decision in Drummond. There is a clear failure to comply with the policy conditions to submit to an EUO, and this court has already held that failure to comply is a material breach of the policy and it bars recovery. So unless the court has any further questions, we will rest on our briefs.
All right, thank you. Ms. Berger, you've got your 5 minutes.
Thank you, Your Honor. Yeah, I'll just address the arguments made by counsel. There is case law to support that the compliance with conditions precedent to filing a suit can be satisfied after the filing of the lawsuit. And that is from this case, this court's decision in Macrolos versus Citizens in 2012. There, the court found that the sworn proof of loss was filed or was sent to the insurance company before summary judgment was entered, and that demonstrated cooperation to some degree. The Drummond case that was cited to by counsel does rely on Goldman, but it was from 2007, and several of the cases that have been cited and referenced here since that time recognize an exception, the exception that applies to Goldman that's being argued here, that there's some demonstration of a willingness to comply and or an explanation for the non-compliance. When these courts are presented with either of these things, partial compliance, some sort of demonstration of a willingness to comply, or an explanation for their non-compliance, courts have found that that's sufficient to create a genuine issue of material fact that should preclude summary judgment. And the Abdo case is not as dissimilar as counsel makes it seem. Here we have the deposition that I would encourage the court to go back and take a look at the few pages where the examination under oath was questioned of appellant, because it's very clear that he doesn't even know what's being talked about. He cannot identify the letter. So, you know, the inference being that this case is more akin to Abdo based on what knowledge the appellant did have at the time, whether or not he was even shown, whether or not he was, whether or not he discussed the strategy with his counsel. Those are questions of fact. The affidavit, although it does say that, you know, at some point in time he knew and, you know, approved the lawsuit, it's not clear if it was the first or second lawsuit. And that affidavit took place sometime after the deposition was taken. So obviously the information or his knowledge might be more fresh at the time the deposition was taken versus the affidavit. And so there's a genuine issue of material fact even created by the evidence submitted by the appellant. And with regard again to the admissibility of evidence, you know, whether or not this information would be admissible at counsel or at trial still involves a question of the proper laying of foundation. You know, if all we have here is the policy and the certificate of non-compliance or non-attendance and the deposition in the affidavit, that's still not enough to support the final judgment. The policy requires a demonstration that there was a request. We don't have documentation or communications to show that there was a request. You know, whether or not this person is competent to testify, you know, I would point this court to my reference to the Mazine versus M&I Bank, where, you know, in a foreclosure case, the bank sent the head of security to identify documents. That person couldn't lay any sort of foundation for the documents that were relied upon, you know, for his testimony. And that's the same thing we have here. This person doesn't provide any sort of information as to who she is, you know, litigation.
I have a question.
Sure.
Were those objections made at the time of the hearing, or are you making those on appeal on the basis that this is not admissible evidence, so I can still argue these things?
In the response, we challenged the foundation or whether or not the insurance company met their burden, specifically with regard to the affidavit. I'm not sure that there is in the record that argument, but it wasn't, preservation was not argued in the answer brief, so that argument has been waived. And there's some authority in this court for the court exercising its de novo review to find that an affidavit offered in support of summary judgment.
You've got one minute.
Sure, is insufficient. And I'll just point this court to the West Edge case that was cited in the Rodriguez case. There, in the concurring opinion, one of the judges on that case, you know, said that the basis for reversal in terms of the sufficiency of the affidavit was not raised in the trial court or in the briefs, but the court still reversed that summary judgment. And again, that's West Edge versus Kundros, I believe. And I would just ask the court to take a look at the more recent case law cited by the appellant, not the older case law cited by the insurance company, and find that there's a genuine issue of material fact here that still remains, and that the burden wasn't met by the insurance company to support a final judgment and reverse and remand for further proceedings.
All right, perfect timing. Thank you. Thank you both. You may now exit the virtual courtroom. I'll be calling the next case, and that's Thomas